Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying contracts and I'm studying situations in which changed circumstance may affect the performance. So there's going to be three situations. The first situation is impossibility, the second situation is impracticability, and the third situation is frustration of purpose. So a party may avoid performance if it becomes impossible to perform due to changed circumstance. So what do I mean by impossible? I mean that it cannot be performed by anybody, not just a specific person to the contract. So it's just anybody. So I'm going to give you a quick example. For example, let's say that there's a person, he has a farm full of cows, and he promises somebody that he's going to sell them 10 gallons of milk. And then what happens is that an accident happens and all his cows die. So suddenly he doesn't have any more milk to sell. So is that impossible for him to sell milk? No, because what he can do, he can go to the grocery store and he can buy 10 gallons of milk and he can sell it still. So it's not impossible. When would it be impossible? Let's say that in a situation of a pandemic with the coronavirus, all the stores close. So when all the stores close and this person cannot even get his hands on milk, at that point, it will be impossible. Because it won't be just impossible by him not being able to get milk, it'll be impossible for everybody because of the situation. So there's actually three types of events that may result in impossibility. The first one is death or incapacity of a particular person who is necessary for the performance. The second situation is a specific thing that is necessary for the performance has failed to come into existence, has been destroyed, or has significantly changed. For example, let's say that a car. You're trying to rent your car to somebody, but then the car is completely totaled, completely useless. So at that point, it is destroyed and significantly deteriorated. So it cannot be used anymore. And then the third situation is the performance is prevented by law, including any regulation or court orders. So it happens sometimes when there's a court order and it becomes impossible to perform because of the law. So the non-occurrence must have been a basic assumption of the contract, not foreseeable and not the party's fault. A party may avoid performance if it also becomes impracticable due to changed circumstance. So what do I mean by impracticable? I mean performance will cause extreme and unreasonable difficulty, expense, injury, or loss to the party. So that's impracticable when there is extreme and unreasonable difficulty, expense, and injury or loss to the party. So under the doctrine of frustration of purpose, a party may avoid performance if his principal purpose is substantially frustrated. So right now I'm talking about substantially frustrated. What do I mean by that? I mean that the other party's performance has become virtually worthless, even if it is still possible or practical. So, what does this mean? This means that the non-occurrence must have been a basic assumption of the contract, not the party's fault. So as long as it is not the party's fault and it is the basic assumption of the contract, that is substantial frustration. So that's pretty much everything I wanted to say from my notes, but I'm not done talking because what I'm going to do next, I want to talk about this book, and I would like to switch to this chapter right here. Take a look. So this is exam tips on impossibility, impracticability, and frustration of purpose. So I would like to talk about some of these tips that this book suggests. So over here, it says that exams often hint at the possibility of a defense based on impossibility, impracticability, and frustration of purpose. And over here, it says usually your fact pattern won't mention any of these defenses. So it's not like you find these defenses automatically. It doesn't work like that. So how it works, issues common to impossibility and impracticability and frustration of purpose comes in these situations that I'm going to talk about. So the first one is assumptions shared by both parties. So you must look at over here, it says, look first to see if both parties made this underlying basic assumption. It's very important. If the parties who's trying to avoid a discharge didn't know that the contract was predicated on assumption, then these defenses will not apply. And then also look at the foreseeability. Over here it says that remember that the more foreseeable the contingency was, the less likely it is that the contingency represents the failure of a basic assumptions. And then finally look at the risk allocations. I'm right here. Risk allocation is the last step in determining whether the party's obligations have been discharged because of impossibility, impracticability, and frustration of purpose, and is to make that risk of one of these outcomes wasn't implicitly allocated to that party by the contract. And then also over here, it talks about supervening illegality, which I talked about. Also frustration of purpose. When dealing with a fact pattern where one party's claimed frustration of purpose, make sure the purpose is totally, not just partially frustrated. So totally, not just partially. For example, illness. In the case is not involving a personal service, a party's serious illness may not lead to total frustration. So if someone is ill, that is not total frustration. And then the next thing over here is impossibility. So when you're dealing with a fact pattern where one party claims impossibility, make sure that the performance is totally impossible and that the event creating the impossibility was unforeseeable at the time of the information. And then finally, I would like to talk about the impracticability here. It says that although increased expenses generally does not rise to level of fulfilling the requirements for impossibility defense, some jurisdictions sometimes allow a party to use increased costs as an impracticability defense. So some jurisdictions do that. And consequence of excuse. Finally, the last thing it talks about here, it says that remember that if the parties are excused from performing, contract damages are awarded because there hasn't been a breach. So I really hope you enjoy studying. This is a really good book and I hope you invest. Good luck.